There's my face. I have Dominique Mallet appearing on my screen. Can you unmute and turn on your video?
How you doing? It says Dominique Mallet, my fiance's, I guess it just saved like that in her computer, but I'm Kevin Anderson.
Kevin Anderson. All right, Mr. Anderson, you are here for arraignment. So what I'm going to do is I'm going to move you into a breakout room with an FDC attorney who can advise you of your rights.
Okay.
Go ahead and accept the invitation. He'll be meeting with someone else, but you have the same stuff to talk about.
All right.
Mr. Humbarger. All right, you're muted.
I'm sorry.
That's okay. I do this all day long, every day, and it still catches me sometimes. The court is calling the case of the City of Kentwood versus Marquise Humbarger, case number 21-50269OT. Mr. Humbarger, the City of Kentwood alleges that on or around April 26th of this year in the City of Kentwood, you operated a vehicle while unlicensed. That is a misdemeanor. It is punishable by 90 days in jail, a fine of up to $500 plus court cost and collateral consequences. There's a civil infraction here as well, failed to yield right-of-way, which is punishable by fines. Do you understand the charges and the maximum penalties?
Yes.
And did you have an opportunity to speak with Mr. Oberholzer regarding your rights?
Yes.
As to the offense of driving while unlicensed, how do you plead?
Not guilty.
All right, the court will enter a not guilty plea for you on the civil infraction. We'll say not responsible for now. We'll have you come back and meet with the city attorney. We'll send you a notice in the mail with the date and time when you need to meet with her. Is your address 1293 Marshwood Court Southeast?
Yes.
That's in Byron Center?
Yes.
And what's a good phone number for you?
616-228-5683.
All right, we will send you notice to that address in Byron Center with instructions for meeting with the city attorney. In the meantime, no driving without a valid license. Do you understand, sir?
Yes. Nice.
I'm sorry?
Yes,
What
I
is-
should have it real soon, like real soon.
Okay. All right, you're all set, sir. Then you may go.
Thank you.
Thank you.
Have a good day.
You as well. Mr. Oberholzer, I have somebody in the lobby waiting for you as well.
Perfect, Your Honor. Thank you very much. Are they here for arraignment as well, I take it, or?
Yep.
Great. Thank you.
All right, Mr. Mallett, remind me again your name. You are Kevin Anderson, is that correct?
Yes, ma'am.
All right. I'm gonna rename you. All right, the court is calling the case of the City of Kentwood versus Kevin Lamar Anderson, case number 21-50275OT. Mr. Anderson, the City of Kentwood alleges that on or around April 29th of this year in the City of Kentwood, County of Kent, you operated a vehicle while your driver's license was suspended, revoked, or denied. That is a misdemeanor. It is punishable by up to 93 days in jail, a fine of up to $500, plus court cost and collateral consequences, including Secretary of State penalties and immigration consequences if you are not a citizen. There is a separate civil infraction here, violation of basic speed law, going 30 and a 25. That carries with it fines, sir. Do you understand the charges and the maximum penalties?
Yes, ma'am.
Did you have an opportunity to speak with Mr. Overholzer regarding your rights?
Yes, ma'am.
As to the offense of driving with your license suspended, revoked, or denied, how do you plead?
I'm not guilty.
All right, the court will enter a not guilty plea for you. We'll say not responsible right now on the civil infraction. We'll set you up with an appointment to come back and meet with the city attorney. Is your address 2351 Sunny Creek in the city of Kentwood?
Yes, ma'am.
All right, that's where we will send the notice, so make sure you watch your mail. You're all set for me today, but in the meantime, sir, no driving without a valid license. Do you understand?
Okay, can I say one thing? I just wanted to I have a Secretary of State appointment for May 25th where I get my license because I paid all my my fines and tickets and stuff off to get my license. So they set it for the 25th. That's when my suspension is up, and I'll have my valid license on the 25th.
That's exciting news. Ms. Lindsay, are you able to set him up with a pretrial conference on or after the 25th of May? Yes. All right, we will do what we can to get you a date to meet with the city attorney after May 25th,
Okay.
because I'm certain she will. June 9 at 9:40.
Okay.
I'm certain Ms. Dawson will be well pleased to see your bright, shiny new license. Make sure you bring it with when you come on June 9th. Okay, sir?
Okay. Thank you.
Thank you. You're all set.
All right.
The court is calling the case of the City of Kentwood versus Marcus Alexander Hendricks. This is case number 21-502610T. You are Marcus Hendricks? All right, yep. I need you to make sure you speak out loud so my court reporter can get it. That's fine. We can't record the nodding of your head. All right, sir, you're here for arraignment. Arraignment is your opportunity to hear the charges being brought against you and your rights as they relate. The City of Kentwood alleges that on or around April 25th of this year in the City of Kentwood, County of Kent, you drove while unlicensed. That is a misdemeanor crime. It is punishable by up to 90 days in jail, a fine of up to $500 plus court costs and collateral consequences. There is also a civil infraction here, failing to yield right of way. That's punishable by fines. Do you understand the charges and the maximum penalties?
Yes, ma'am.
And did you have an opportunity to speak with Mr. Oberholzer regarding your rights?
Yes, ma'am.
As to the offense of driving while unlicensed, how do you plead?
I plead not guilty.
All right, the court will enter a not guilty plea for you. Sir, is your address 4205 Nature Trail Drive?
No, ma'am, I recently moved.
What is your correct address?
1095 Woodville East Side.
Is there an apartment number?
6.
Is that in Kentwood?
Yes. Oh, I guess you say that. It's
What is the zip code?
19508. I think it's like 4.
It is. It is
It's
a,
super confusing.
we have very porous borders.
Yeah.
All right, sir, we'll say not responsible for the civil infraction at this time as well. We will send you a notice with a date and time to come back and meet with the city attorney. We'll send it to that Woodfield East address. What? Oh, that's right. You're here in person.
Yeah. I have a,
Yes,
I did have an appointment set up.
with the
for-
Secretary of State.
Yes, ma'am, for June 2nd.
Okay.
So I was, working on.
Can we get him in on June 9th then? All right, so here's what we'll do. We'll make sure your pretrial date is after your appointment. I'm gonna make a note in this file that you told this court you have a Secretary of State appointment when? June 2nd?
I'm sorry, this is a lot of work, but okay.
Your Honor, I just believe he's a little overwhelmed, just being in court, and this is his first time, so.
Court can be a little overwhelming. I try not to make it too arduous of a process for,
It's not paying the tickets and stuff.
Mhm. Well, and I understand that you don't want to go to jail. The thing is, this is not a ticket. It is a misdemeanor crime punishable by jail time. And so it's going to benefit you the most to go to your appointment with the Secretary of State, get your license, and come back and show it to Miss Dawson, who is our city attorney, on June 9th.
Okay, so June 9th.
June 9th. If you'll step over to the side, my clerk's going to give you a notice. So you'll walk out of here knowing when you need to return, okay? You're all set with me today, but in the meantime, no driving unless you have a valid license.
Thank you, Your Honor.
Thank you, Mr. Oberholzer.
We don't have anybody waiting for that, correct?
I don't believe so. You're done with everyone who's here in
I
person.
believe so, Your Honor, I didn't see
And
anyone
there's
else
no
up
one
there.
waiting in Zoom. Okay. We're gonna have a couple more warrants to do when you are.
I need to pull the court date and, share with them what's going on. Court dates, you can-
62D District Court is now in session with the Honorable Amanda Sterkenburg presiding.
Good morning, Mr. Heemstra.
Good morning, Your Honor.
Appearing on my screen is phone number ending in 6895. Can you unmute and identify yourself, please? I have a litigant who has called in to Zoom using the phone dial-in number. The phone number ends in 6895, but you're muted, so I can't hear you speaking. I'll need you to unmute before the court can assist you.
Judge, I do believe that is Sharon Johnson because that's her number that matches up to what I have for her.
I have every reason to believe it is, but she can't participate if she's on mute.
Right.
And the challenge with litigants who call in then is that I can't use other tools such as chat feature.
Yeah.
I see you have unmuted yourself. Are you Sharon Johnson?
Yes,
All right. The court is calling the case of Community West Credit Union versus Sharon Michelle Johnson, case number 17-5731 GC. Counsel, your appearance for the record.
Yes, Chuck Heemstra on behalf of the Plaintiff Community West Credit Union, P number 24332.
And ma'am, you are Sharon Michelle Johnson, correct?
yes,
You're appearing by phone today using Zoom technology. We are
yes,
here on your objection to garnishment. So a periodic garnishment was filed in this matter pursuant to a judgment. That periodic garnishment is dated March 24th. You sent a letter to the court which sufficed as an objection, and so the court scheduled this motion. I read your letter. I'm going to give you opportunity to add to that anything that you want the court to consider, and then I'm going to have Mr. Heemstra give his argument as well before I make a determination. All right, ma'am. So what would you like the court to consider on your objection?
I don't know. It's just, I think I wrote everything. I'm a kind of pain helper, and I just try to work when I can so I won't be homeless again.
Mr. Heemstra, you received a copy of the letter we received, correct?
That's correct, Judge.
All right. And I read your response and brief. Ms. Johnson, did you receive a copy of the response filed on behalf of Community West Credit Union?
That Mr. Hinkster said, but Your Honor, I'm afraid I don't understand it all, so,
I'll have Mr. Heemstra go ahead and give his argument.
Well, Your Honor, it's pretty much contained in the small brief that we presented. I don't think she's alleged any basis under the court rule for the invalidity of the garnishment. And unfortunately, now is not the time to raise anything with regard to the judgment that was entered. So we would just stand on our response brief.
Thank you. So, Ms. Johnson, what he's saying is a couple things. First of all, your objection includes comments about the original debt, the underlying debt, and that has already been adjudicated. So what you owed was already ordered in this case. And so any information that you provide now can't go back and attack that judgment. The judgment is what it is. It has not been set aside. But the garnishment then is what you are objecting to. And I recognize that you are in a period of financial hardship, but none of the facts that you allege, while creating a a totality of circumstances for you that is difficult. None of them are sufficient and valid defenses against the garnishment under the law. So I can't set aside the garnishment based on your objections. They aren't valid, but Mr. Heemstra, I think it's within my discretion to order you to negotiate for a payment plan with Ms. Johnson. Do you have authority to engage in negotiations for a payment plan on this matter?
I do, Judge, have authority to negotiate. Certainly, they'll always negotiate with an installment payment arrangement, but I don't know what the circumstances are to let them know exactly what her earnings are, that type of thing. So I'd probably need to get specific authority for any dollar amount.
All right.
I'm
So,
happy to do that with Ms. Johnson. Even talk to her today about it if that's something she can afford to even offer or do.
well, why don't we do this? The court's happy to oblige. I can place you into a breakout room together. We can go off the record now, let you two have a conversation about what's a reasonable potential payment plan. See if you can get authority to accept that amount, and we can put that on the record right now.
Sure.
Okay, Ms. Johnson, because you called in, I'm gonna open a breakout room and place you in it to have a private conversation with the attorney. So I'll move you into that room, but you won't be able to come back. You'll actually have to disconnect and then call back into the original Zoom room because you have called in on the phone and not using the video feature. You understand?
Call back the same number that I called.
Yep, after you have this conversation with Mr. Heemstra.
Okay.
Okay, so I'm gonna move you into a breakout room right now. Mr. Heemstra, it's called prosecuting attorney. That's what I was titled today, but
Oh,
plaintiff's
okay.
attorney.
All right. Leaving you to join. Oh, so I'm not joining prosecutor. If I hit join, I'll go into the chat room.
No, you're joining the prosecutor's office
Oh, okay.
breakout room. That's what it's titled. For whatever reason,
Okay. All right.
plaintiffs, I only have prosecutors today.
Okay. All right.
This is my
Okay.
only civil matter on the docket.
Okay. Thanks. I'll get into the prosecutors.
Okay.
Thank you.
Mm-hmm. Welcome back, Mr. Heemstra. We have to wait for
Sure.
Ms. Johnson to rejoin us by calling back in. That is one of the less advantageous features of Zoom. It offers the ability to call in, but without the flexibility of being able to move participants around.
Yeah, I understand. Well, I talked to her. I think she knows she's gonna call back in. So I said, do you have the number? Yeah. Can you call it back again? She said, yes.
Well, we'll wait and see when she pops into my waiting room. I'm sure.
Yeah, she'll be fine. Well, I have to apologize. My secretary still put William G. Kelly on the face of my brief.
It appears in a number of places still. We catch it and correct it as we go along. Lot of documents in this courthouse that have templates with William G. Kelly on it.
Well, Judge Kelly and I go back to age 4.
Oh my goodness.
Yeah,
Wow.
on
right,
Bemis Street.
Miss Johnson, are you there?
Yeah,
All right, we are back on the record in the matter of Community West Credit Union versus Sharon Michelle Johnson. The parties had adjourned to discuss a potential payment plan and had a conversation in a breakout room. Mr. Heemstra, was that a fruitful conversation?
Well, yes and no. Here's the deal. She only works about 14 hours a week at $12 an hour. Nothing's ever been taken out of her check, and my guess is she's under the threshold, so nothing will be taken out of her check. Doesn't look like she's going to be gaining any more hours or employment. And right now she claims that, there's just nothing she can do by way of an installment payment because she needs everything to live on. So it doesn't sound to me like she's going to have any concern with that garnishment.
All right. Well, Ms. Johnson, again, the court recognizes the dire financial situation that you have described. Nonetheless, the objections as stated are not valid in the face of this periodic garnishment, which is pursuant to a valid judgment. And so I am denying your objection.
Judge, one thing I didn't mention to her is if she does get higher earnings or something does come out of her paycheck, she should probably file a motion with the court for installment payment. She can call me certainly, but if we couldn't agree, I didn't mention to her she could file a motion with the court for an installment payment.
Right. Well, and Mr. Heemstra, that's good of you. It's not even really your responsibility to do so, to advise her as such. But Ms. Johnson, what he is saying is that there is an avenue for you. You can file a pleading with the court seeking an installment payment if your income rises to a level where this garnishment starts to become effective and or you become in a position to pay on a monthly basis.
okay.
And Ms. Johnson, you can call me anytime, okay?
I would suggest that probably the best way to handle it, ma'am, is to keep in touch with Mr. Heemstra. He's not a bad guy. And work with him to resolve whatever you can in terms of, maybe negotiating a payment plan down the road or any other kind of resolution. For now, your objection is denied. I'll enter the order. We're going to send it out to all parties. We're all set in this matter. Thank you.
Thank you, Your Honor. Thank you, Ms. Johnson.
Okay.
All right, Ms. Johnson, you may go. You can disconnect.
Thank you.
It's nice. Mr. Overholser, this is your client, Ms. Jones.
Yes, Your Honor. And I do believe we are ready to proceed unless Ms. Jones would like to go into a breakout room if she has any questions or anything. I think otherwise we're ready to proceed at this time.
Ms. Jones, if you could unmute yourself. If you need more time to speak with your attorney, I'm happy to oblige. Otherwise, we are prepared to move forward on your case.
I'm ready to move forward.
Okay. The court is calling the case of the City of Kentwood versus Deandra Marie Jones, case number 21-501030OM. You are Deandra Jones,
I am.
and Ms. Jones appears with her attorney Kurt Overholser for sentencing on what was originally charged as 2 counts of assault and battery. One is to be dismissed as a result of your successful plea and sentence. Ma'am, assault and battery is a misdemeanor offense. It is punishable by up to 93 days in jail, fines, and court costs. Mr. Overholser, the court has a pre-sentence investigation report and recommendation. Have you had a chance to review that with your client?
I have, Your Honor. We did have a chance to review that together, Ms. Jones and I did, Your Honor. And at this time, I don't believe we have any additions, challenges, or corrections to make to that pre-sentence investigation report, Your Honor.
Thank you. I think that when that report was authored, I had not, the probation department had not yet received a victim impact statement, and there is one in the file now. So give me just a moment to review that. It is a victim impact statement authored by one Samantha Wright. All right, Mr. Overholser, I will hear your allocution in this matter.
Absolutely. Thank you very much, Your Honor. Your Honor, I'd like to start out just by pointing out that working with Ms. Jones has certainly been a pleasure, Your Honor. She's taking this matter extremely seriously. And at my first meeting with Ms. Jones, I could right away tell, Your Honor, that she was very remorseful, extremely remorseful for her actions with regard to this case, Your Honor. She knows that she made an extremely bad and poor decision, and I certainly think if Ms. Jones could go back and make a different decision, she absolutely would do that, Your Honor. So she realizes that it's not right what she did. She certainly could have acted a different way, but nonetheless, Your Honor, she is here to accept responsibility for her actions here this morning before the court, Your Honor. Your Honor, I'd like to just point out a couple positive things Ms. Jones does have going on in her life, which are highlighted in the pre-sentence investigation report. But just to reiterate, she is currently working, Your Honor, with Uber. She's been doing that for approximately 2 years now. It is tough for Ms. Jones because income isn't necessarily always steady. It does fluctuate at times. Like Ms. Jones just described to me last week, because the weather was nice, I think her business went down a little bit. So it's not always exactly a predictable income, but it is certainly help her pay the bills. And she's been doing that for 2 years and does enjoy doing that. I do think Ms. Jones potentially may be looking for some additional work at this time as well. But nonetheless, she is still working with Uber right now and earning money that way, Your Honor. I did have an opportunity to discuss with Ms. Jones, and as it's noted in the pre-sentence investigation report, Ms. Jones does have some goals here moving forward in terms of what she would like to see happen in her life moving forward. We've talked about, and again, as it's noted in the pre-sentence investigation report, she is interested in potentially pursuing a career in medical billing and coding. So, I've encouraged Ms. Jones to certainly, pursue that career if that's something that she's interested in doing. So, she is concerned about how some of these cases, may affect her ability to acquire employment. in that area, but she understands that's a consequence of her actions. And I'm hopeful that Ms. Jones, this will be, the last time she is before a court, so that hopefully she can continue, living a good life and working towards, possibly being able to achieve, some of her goals in the career area she wants to. As it's further noted in the pre-sentence investigation report, and I think it's great that Ms. Jones did indicate she is very absolutely interested in getting involved in some counseling to address her anger issues. In fact, in discussing this case with Ms. Jones, she even indicated to me, Your Honor, that she wished that at the time of the incident, she would have actually been involved in some counseling, as maybe it would have given her some of the tools to allow her to make that better decision, the one that she would have rather made rather than the incorrect one here. So she is very interested in hoping that she will be able to get involved in some counseling soon. And so I would just like to note that. With regard to a likely no contact order that this court, I would assume, is likely to continue here with the Burger King and the victims on this case. Ms. Jones has absolutely no problem whatsoever, Your Honor, with not going back to the Burger King or any Burger King locations, and certainly has no plans to make any contact with the victims in this case. Ms. Jones doesn't have any personal connection to them. They were just employees at the time. And so there shouldn't be any issue whatsoever if this court is to continue a no contact order with Burger King and the victims. Otherwise, Your Honor, Ms. Jones is a proud mother. She does have one child, a 9-year-old daughter. That daughter did just recently start attending regular school here full time again. She's currently in the 4th grade. And so it's been a little bit of an adjustment. She was doing Zoom school here, and Ms. Jones was helping, teach her daughter and be there to help her through her schooling when she was home. But so it's been a little bit of adjustment going back to the regular schooling, but I think, they're getting used to that. And it seems like her daughter's doing very well in school and otherwise. And I know Ms. Jones cares very much for her daughter. Just to touch on the pre-sentence investigation report does note, Your Honor, that Ms. Jones is on that non-reporting probation out of the Wyoming District Court. I'd just like to state that this incident, from my understanding, Your Honor, did happen prior to her being placed on probation out in the Wyoming District Court. So I'm hopeful that there shouldn't be any issues for her given that fact, Your Honor. And so with that being said, Your Honor, again, Ms. Jones is absolutely and extremely remorseful. I'm sure she could speak to, her feelings about the case certainly better than I could, but I do know in working with her that she's taken this very seriously, absolutely wishes she could go back and make some different decisions, but she is here to, accept responsibility for that mistake she made and certainly, is ready to accept any sentence that this court hands down. We would at this time just ask the court respectfully to go along with the plea agreement, which was negotiated on Ms. Jones' behalf, and to not sentence her to any jail at this time, rather give her a chance to prove herself on a probationary period. I do think Ms. Jones will do tremendously if she is given that chance and will be an outstanding probationer for this court, Your Honor. And with that being said, we certainly thank the court for its time. And thank you very much, Your Honor.
Thank you, Mr. Overholtzer. Ms. Jones, is there anything that you would like the court to consider before I impose sentence?
Yes, Judge, I do know what I did was so wrong to the victims and also for myself. I do have goals and I should have been more controlled, and I am sorry. So.
All right, well, it is meaningful to this court to hear your genuine remorse. I will read to you from the victim impact statement that the court received. Please explain your reaction and how this incident has affected your life. I was shocked that someone would even do that. I felt hurt, violated, disrespected. I am scared to work the drive-thru. These are people that you did not know, ma'am, and you've had a serious impact on their life because you weren't able to control your own emotional reaction to something that I bet if you look back on was certainly not worth what it has cost you in terms of your time, investment, and potentially job opportunities moving forward with this on your record. So I will go along with the recommendation of the probation department. Sentencing has many purposes. There's the punitive aspect, which is, of course, the punishment that you get for having broken the law. There is a restorative element. To my knowledge, no one is requesting financial compensation at this time. Mr. Overholzer, are you aware of any restitution being asked?
No, I am not aware, Your Honor.
And then, of course, there is the rehabilitative element, which brings a person back to a position of normalcy. Your behavior here was not normal, ma'am. It is not what a healthy adult individual who is the mother of a 9-year-old child does when confronted with a price discrepancy over a Burger King meal. It is not, and you know that. And so, to meet the rehabilitative goal of sentencing, I will place you on probation with this court. It will be for a period of 8 months. It will be for the purpose of assisting you in developing some tools to manage your anger and some counseling to work through whatever triggers you may have so that you don't find yourself in a similar situation on down the road. The provisions of your probation are as follows. You are not to violate the laws of any city, state, or federal government. You are not to leave the state without the court's permission. You are to make a truthful report to the probation officer monthly or more often as they require. This is reporting probation. You are to notify your probation officer immediately of any change in address or employment status. You are not to possess or consume any alcohol or marijuana or other drugs unless prescribed by a physician. You are not to be in the presence of anyone using illegal drugs or misuse prescription drugs yourself. Ma'am, I recognize that it does not speak to, there is no specific allegations of substance abuse or being under the influence at the time of this offense. But as I get older, one of the things that I become more and more convinced of is that if you are engaging at any time in substances in your life, it has an impact even later on your physiology and the way you perceive and respond to fight or flight situations. And so we're going to give you some time without any alcohol, marijuana, or other drugs. You will submit to alcohol and drug testing, and you will pay for that testing. You will complete and continue any counseling as directed by probation. I'm going to suggest that that be an anger management course, but they will determine what is most appropriate to you. You are to have no contact with Samantha Wright or Gabriel Waters, and you are not to be on the premises of any Burger King location. You are not to purchase or possess any firearms, ammunition, or dangerous weapons. You are to seek and maintain employment and verify that with your probation officer. And I am sentencing you to 40 hours of community service. Once you get the referral from your probation officer, you have 2 business days to get enrolled in community service, or it will be considered a technical violation of your probation. I don't want you waiting until the end of your probation to get started on this. Ma'am, I'm not imposing any suspended jail sentence or any jail time up front. You must pay fines and costs. I'll total them now. Fines and costs in this matter total $1,135. I recognize, given your financial situation, it will be difficult to pay those off at one time, and so we will allow you to engage in a payment plan. I will place you into a breakout room with my cashier upon the conclusion of this hearing, and then you will be able to make payment and payment arrangements. This is a final order of the court. If you disagree with the court's decision, you have 21 days to appeal it to the circuit court. If you need the assistance of an attorney to help you with that appeal, you have 14 days to request one. Do you have any questions for me?
No.
All right, ma'am, I'm going to move you into a breakout room with my cashier, as I said, so that you can make payment. Someone from probation will be reaching out to you to get you set up with your first appointment. Is your address still 3010 Byron Center, apartment 303?
Yeah.
Is that Byron Center Road?
Avenue.
Is that in the city of Byron Center?
It's Byron Center Avenue, Wyoming, Michigan.
Okay. All right, you should have an invitation on your screen to join my cashier. You're all set. Thank you, ma'am.
Thank you, Your Honor.
Thank you, Mr. Overholzer. Appearing on my screen as a series of letters and numbers that end in AS. What is your name, please?
I believe they said Mr. Price, Your Honor. Is this Thomas Price?
Yes.
Perfect, Your Honor. I represent Mr. Price. If the court would allow it, I would just request a brief breakout room so I could touch base with Mr. Price before we do proceed.
Happy to oblige. Mr. Overholzer, you should still have your breakout room invitation. Mr. Price, watch your screen. You can join a breakout room with Attorney Overholzer to discuss this matter before we move forward.
Thank you, Your Honor.
All right, I have a couple of other individuals joining me.
Your Honor, Attorney Ken Stovall.
Mr. Stovall, what can I do
Yes.
for you?
Don't we have a sentencing or no?
You represent Mr. Sanders?
Yes, we were in the wrong Zoom room. I don't know. I'm being told that there was did you put a warrant out, a bench warrant for Mr. Sanders or no?
I did not put a warrant out for Mr. Sanders. He was scheduled to be here at 11. He's not that late.
Okay, yeah, he should be in the room. I don't know if you see him. He should be.
Now, is that Mr. Sanders appearing on iPhone?
Yes,
Mr. Sanders, can you hear me?
Yes.
yeah, that's him. Okay.
I want to spell it. K-A.
You got it?
All right. Do you need an opportunity to speak with your client in a breakout room, Mr. Stovall?
No, I don't, Your Honor.
All
We
right.
spoke it this morning already.
All right. The court is calling the case of the state of Michigan versus Kahari Sanders, case number 20-30194 SM. Counsel, your appearance for the record.
Kenneth Stovall for the defense, Your Honor.
Morning, Mr. Stovall. And you are Kahari Sanders appearing on my Zoom screen?
Yes.
All right, this matter is scheduled for sentencing this morning. I received a pre-sentence investigation report and recommendation. Did you receive that report, Mr. Stovall?
I did not.
Oh, see, that's why.
But it's not their fault, Your Honor. We had some confusion with the mail. They sent it out to Benton Harbor. Mr. Sanders is here in Grand Rapids, so there was a little bit of confusion.
Well, let's see what I can do to assist, because I'd like you to discuss it with him before we move forward.
Okay.
Give me just a moment. I think I have it in digital form.
Okay.
I do have it. And so if you would like to put your email address in the chat, Mr. Stovall, I can email this to you so that you can have that conversation with your client.
Okay, let's see.
All right, I see it. I'm going to copy and paste so I don't mess it up.
All right. Because there is an underscore in there, Your Honor. So
I see it.
be careful.
All right, here we go. I forwarded that on to you, so you should just have it in moments.
Okay.
And I will go ahead and move you and your client into a breakout room so you
Okay.
can discuss the report and recommendation.
That's fine. Thank you, Your Honor.
All right, appearing on my screen as iPhone. I cannot see you. I need you to unmute, turn on your camera, and identify yourself for the court.
Dakari Terrell.
Dakari Terrell, you are the alleged victim on one of these matters, correct?
Yes.
Okay, ma'am. Is that on Sanders? Ms. Terrell, is that on Sanders?
Yes.
Okay. We have not that case yet. Well, we called it, but we weren't able to proceed. And so if you would like to give comment, the court would be happy to hear your comments. You can either stay on with your video or turn it off, whatever you feel more comfortable with.
Okay. I'm going to turn it off.
What's wrong? What's wrong? Come on. Hey.
Jennifer, I need Mr. Torrey's file back.
Hey.
I think I get, oh,
Yeah. 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 Go on, feet. Quit fighting me. Down. Come on. Stay.
all right. The court is calling the case of the state of Michigan versus Hugh Javon Torrey, case number 30353 ST. Mr. Torrey, are you there? Mr. Torrey, it's your turn. Mr. Torrey, can you hear me? Oh, it does not appear that he has his audio on. And so I am going to send Mr. Torrey a chat to turn his audio on. All right, Mr. Stovall and Mr. Sanders have rejoined the court. And did you receive then the pre-sentence investigation report and recommendation, Mr. Stovall? I'm going to need you to unmute.
I'm sorry, Your Honor. Yes, I did, Your Honor, and I didn't know it, but my client had the pre-sentence report already. So he disagrees with nothing on there except he's hoping that Your Honor would end the, depending on what your sentence is, of course, Your Honor, today, or contingent on your sentence, that the no contact order could possibly be lifted. The two share a child. This was a night of drinking and a mistake. And I'm sure Mr. Sanders will go into that further, but go ahead, Your Honor.
Well, I will advise you that the victim in this matter is present, and I will give her opportunity to speak.
Okay.
So
Okay.
what he says, I may make
Okay.
a determination on the no contact provision. And
Thank you.
so you're welcome. Mr. Kahari, you pled guilty as charged to the offense of domestic assault that is punishable by up to 93 days in jail, a fine of up to $500, plus court cost and collateral consequences. I'm going to ask your attorney to speak on your behalf, and then I will hear your comments and the victims. Mr. Stovall, I'll hear your allocution.
Thank you, Your Honor. Mr. Sanders has been very forthright concerning this situation. And I've also spoken to the victim in this situation. Both understand, I believe, that this cannot happen. Mr. Sanders, at least through me, is aware that we must control our emotions and we must keep our hands to ourselves. And the victim in this case, I've also spoken to her, she might tell you, and I've told her that a man that hits you is not worthy of you. So with that, along with that though, they do share a child. Mr. Sanders takes care of his children. He's often, every time I see him, he's with a child at least. And I think that he has been sorry for this. And I'm hoping that when he speaks to you, he is able to convey the fact that this will not happen again. And I hope that it does not. Thank you, Your Honor.
Thank you, Mr. Stovall. I don't see that there was any plea bargain that this was to be sentencing pursuant to 769-4A. Am I correct?
No, this is just a no jail recommendation. That's it.
All right. Mr. Sanders, I'll hear whatever comments you have for the court.
Can you hear me?
I can.
Yes.
I just wanted to say, Your Honor, I apologize for the incident. It will not happen again. Like I said to my lawyer, I'm guilty of the charge. Don't want to try to escalate it to anything else. And that's really it. The only thing that I had an issue with, like we said before, is the no contact order because we do share a child. And that's really it.
All right. And I do have Ms. Terrell here, who is the victim in this matter. Ms. Terrell, if you could unmute yourself, I'd be pleased to hear your comments as they relate to Mr. Sanders' sentence. And he is requesting the no contact order be lifted. I will need your input if that is in fact something that you are interested in.
I am interested. I do agree.
You are asking the court to lift the no contact provision?
Yes.
Are you asking the court to lift it only for child purposes or for all purposes?
For all purposes.
All right, ma'am, I read the affidavit of probable cause in this matter, and the no contact order that is in place currently has within it punishment for Mr. Sanders if things get out of hand again and you are harmed. If that no contact order is lifted, I can't guarantee what's going to happen between the two of you. How can I be certain that you are going to be safe?
I am going to be safe. It was just one night of a bad, emotions. So I'm pretty sure nothing is going to go on anymore. We do have to have contact for the child purposes. So I do want to get them.
Are you going to seek to have a relationship with Mr. Sanders?
At this time, I do want to have a relationship with him so that he is able to see his child.
All right. Mr. Sanders, are you under court supervision anywhere else?
Yes, it's in Benton Harbor as well.
But you live here. Do you live in Benton Harbor then?
Yes.
long are you on probation in Benton Harbor?
I'm not on probation at the moment. I have current pending cases in Benton Harbor as well.
Oh, well, that's right. I see. You're pending trial on felony offenses in the 17th Circuit Court as well, correct?
Yes, I believe so.
Your Honor, I'm his attorney for all of those cases, including the Benton Harbor one as well.
All right. And so is he on pretrial release in all of those cases?
Yes, he is, Your Honor.
All right. Is he reporting to court services?
You broke up on me, Your Honor.
He reporting to court services?
Yes, he is, Your Honor.
Yes.
All right. You live in Benton Harbor, you said, correct?
Correct.
All right. Sir, all the courts find themselves in a unique situation right now as jury trials have been postponed, and that has led to much longer periods of pretrial release for people. I don't know anything about your other matters, but if you are in pretrial release, you are innocent because you have not yet been proven guilty. You are reporting to court services, and so I'm not going to add an additional element for you of another place that you have to drop and do testing. But I think that in this interim period, it's going to be really beneficial to you to engage in some kind of counseling or anger management or other type of rehabilitative programming to really kind of get your life back on track so you can be the right kind of father, to be the father to this child that you really need to be. And so this court is going to place you on probation. It will be for a period of 12 months. The provisions of your probation are as follows. You are not to violate the laws of any city, state, or federal government. You are not to leave the state without the court's permission. You are to make a truthful report to your probation officer monthly or more often as they require, and they may allow you to do that via Zoom. You must notify your probation officer immediately of any change in address or employment status. You are not to possess or consume any alcohol or marijuana or drugs unless prescribed by a physician. I assume you are dropping for court services, so if you're dirty for them, we will know. You are to complete or continue counseling, pay the fee, and verify that with your probation officer. You are not to purchase or possess any firearms or ammunition or dangerous weapons. You are to seek or maintain employment and verify that with your probation officer. I am imposing 60 hours of community service in this matter. You will have jail of 3 days with credit for 3 days served, and you will pay fines and costs. I'll total them at this time. Where are you working, sir?
At G. Bender's, a construction job in Benton Harbor.
And Mr. Stovall, are you appointed on this matter or retained?
I'm retained, Your Honor.
Okay. Fines and costs in this matter total $1,005. That is the final sentence of the court. If you disagree with the court's decision, you may appeal it to the circuit court. You have 21 days to do so. If you need an attorney appointed to help you with that, you must request one within 14 days. Sir, I have your address as 586 Niles, Niles, in Benton Harbor, 49022. Is that correct?
Correct.
All right. Someone will reach out to you from probation. I have a phone number of 606-8588. Is that correct?
Correct.
All right. And I'm going to place you into a breakout room right now with my cashier. We'll allow you to make payment or payment arrangements if you need a payment plan. And you're all set. Thank you very much. Thank you, Mr. Stovall.
Thank you, Your Honor.
Mr. Sanders, watch your screen. I'll be meeting with my cashier. Mr. Torrey, have you turned on your audio yet? Mr. Sanders, go ahead and make sure you click join breakout room. There you go. Mr. Torrey, I cannot help you if you do not turn on your audio. I've sent you a chat to turn on your audio. I've called your case. Cannot see you. Mr. Torrey, I am going to give you another minute or so, and then I'm going to remove you from the meeting, which is a shame because you were supposed to be here at 9 o'clock. A couple hours late, but I'm still happy to see you. Mr. Overholzer, I see Thomas Price there as your client. You need to speak with Mr. Price. You did, right? We moved you into a breakout room and now you're back.
Correct, Your Honor. We're ready to proceed, Your Honor, at this time. Thank you.
Hold on, there's Mr. Torrey. Mr. Torrey. Please turn on your audio. Yes, you. You need to select join with audio. That was not what I hoped would happen there. All right, the court is calling the case of the State of Michigan versus Thomas Edward Price Jr. Mr. Price Jr. has two files before the court. The first is case number 21-30071 SM. The second is 21-30034 SM. Are you Thomas Price?
Yes, John.
All right, Mr. Price, do you have video that you could turn on? All right, you are Thomas Price?
Yeah.
All right, I need to make sure that you speak into the microphone that you have on your phone so my court reporter can pick it up. Mr. Price is here for sentencing on these two cases. In each, he was charged with domestic violence, which is a misdemeanor punishable by up to 93 days in jail, fine of $500 plus court cost. Mr. Oberholzer, the plea included no objection to sentencing under 769-4A, correct?
Correct, Your Honor. And just to make a brief addition, it also included a dismissal of file 21-30034 SM if Mr. Price pled guilty to file 21-30071 SM, Your Honor.
Let me verify that. Yes, that is correct. File ending in 34 is to be dismissed per the plea bargain. So upon your successful sentence today, that should be what happens, sir. I did receive a pre-sentence investigation report and recommendation. Did you also receive that, Mr. Oberholzer?
I did, Your Honor. Thank you very much. And I did have an opportunity to go over and review that pre-sentence investigation report with Mr. Price, Your Honor. At this time, we have no additions, challenges, or corrections to make to that pre-sentence investigation report, Your Honor.
All right, well then I will hear your allocution.
Well, absolutely. Thank you very much, Your Honor. Your Honor, Mr. Price is before the court, certainly accepting responsibility for his actions. I think to just sort of summarize the situation, Mr. Price understands moving forward, certainly, that he needs to, treat his family with the most respect, both his siblings, all of his family with respect, Your Honor. And I think he sort of learned that going through this situation, again, that he does need to do that, treat his family with the utmost respect. Certainly his brothers, his mother, everybody, frankly, Your Honor. And so, again, Mr. Price is here to accept responsibility for his actions. And I believe moving forward, will be doing that and treating, certainly his siblings with more respect. Mr. Price, Your Honor, is currently gainfully employed, as pointed out in the pre-sentence investigation report. He did. I'm happy to announce that he was able to obtain his job back with Wolverine Glass Company. He's currently working approximately 45 hours per week, 9-hour shifts. They make glass there, so I think Mr. Price enjoys his time working there and plans to continue working there for at least the time being. My understanding is that Mr. Price is still working towards obtaining his GED, Your Honor, through the Wyoming Adult Education Program. So I know that is a condition of his probation on his other case. He's on probation with this court. And I would anticipate this court to also make that another condition of this probation to have him continue obtaining that GED. And so my hope is that Mr. Price will continue forward working towards his GED. And as Mr. Price and I have discussed, I think if he is able to do that, it will certainly open up a number of different opportunities that he may not have otherwise, Your Honor. So he's certainly being encouraged to move forward with that. Since this court did lift the no contact order with regard to this case, Your Honor, I'm also happy to further report that everything's been going well within the household. I don't think there's been any additional incidents between Mr. Price and his siblings, and it seems like everyone's getting along well and everything's going very well. Again, I do think Mr. Price has a renewed sort of, respect for his family and is, honoring that and treating everyone with respect within his household. And so, again, no additional incidents or issues have come up to my understanding, Your Honor. I'd also like to just point out the fact that Mr. Price, he is a young individual, Your Honor. He does have tremendous family support, though. I've had the opportunity to see Mr. Price on numerous occasions, him appearing in court in person, where his uncle was present, his mother was present on 2 other occasions. So, he certainly does have people in his corner that are wishing him the best. And so I think that's definitely something good that Mr. Price does have going on in his life. And I hope that he will take advantage of that good support system that he does have. We also touched on, counseling, the fact that Mr. Price, I don't believe has ever been involved in any sort of counseling, but in discussions I've had with Mr. Price, we've talked about, anybody can benefit from counseling. And if this court is to order that for Mr. Price, I think he's looking forward to potentially being able to go talk to somebody about any issues that he may have going on in his life. As again, I think, that can be beneficial for anyone and everybody. So, and then just lastly, Your Honor, Mr. Price and I also have had many conversations with regard to 7694A, the diversionary statute that was negotiated as part of the plea agreement. We are respectfully asking this court to sentence Mr. Price under that diversionary statute. And furthermore, we've had a chance to talk about the huge second chance that this does present to Mr. Price. Mr. Price understands that if he does, get through probation successfully and does good on that probationary term, that at the end of it, this case theoretically would, or not theoretically, would be dismissed and off his public criminal record. And I hope Mr. Price understands what a huge opportunity that is. And I think he does, Your Honor. And I think and very hopeful he will take advantage of that second chance if the court is to grant him that. And hopefully see this case dismissed off his public criminal record here at the once he does successfully complete his probation. So with that being said, Your Honor, we would respectfully ask the court to consider a term of probation for Mr. Price pursuant to sentencing under the Spousal Abuse Act, the MCL 769.4A. And with that, Your Honor, we certainly thank the court for its time and thank you very much.
Thank you. Mr. Price, is there anything that you would like to add before I impose sentence?
Yeah, I've been trying to forgot what I was going to say. I'm sorry. I'm so sorry. But everything's been going good in the house, with me and my siblings, and I just want to let you know.
Well, I'm glad to hear that things are going well in the house. I do recall when your mother came and spoke on your behalf and asked for the no contact order to be lifted, which it was. And so I will not add any no contact order or premises prohibition into this order of probation. But Mr. Price, you got me thinking, you're 18 years old, correct?
Yeah.
At 18, this is supposed to be that period in your life where you are first experiencing freedoms and the advantages of being out of being a minor. You are at the age of majority, right? So this is the beginning of your life, and yet you have set yourself up to be monitored, not free, for the next at least 14 months or so. You will be under court supervision. And so that is unfortunate, I think, but perhaps it is necessary for you because you weren't quite ready. And so I am placing you on probation with this court pursuant to 769-4A, so that you have the opportunity to keep this assaultive crime off your record, and so that you can gain some tools and coping mechanisms that will position you better for the next time you get a shot at freedom to be doing exactly what you're supposed to do, right? And operating within society as a functional member, and a functional member who has their GED. So being cognizant of the fact that you were already on probation with this court, I spoke to Mr. Bastians, and all unfinished provisions of your prior probation will be rolled into the terms of this, but the term in this case will be 14 months. And during that time, you must comply with the provisions of your prior probation. And I don't have it handy, so I'm going to go over them all again and make sure that they are all fresh in your brain, so that these are the things that you know that you have to abide by. You are not to violate the laws of any city, state, or federal government. You are not to leave the state of Michigan without the court's permission. You're to make a truthful report to your probation officer monthly or more often as he may require. Notify him of any change in address or employment status. You are not to consume or possess any alcohol, recreational marijuana, or drugs unless prescribed by a physician. You are not to misuse prescription drugs or be in the presence of anyone using illegal drugs. You will submit to alcohol and drug testing and pay that fee. You will complete or continue counseling as directed. We'll give you a screening and determine what's going to be the most helpful and place you into that kind of program so you can get what help you need specific to your situation. You are not to purchase or possess any firearms or ammunition or dangerous weapons. You are to seek or maintain employment and verify that with your probation officer. You are to attend your educational programming and obtain your GED. I am not adding any suspended jail sentence or upfront jail on this. So I want to see you be successful. At 18, I have a lot more desire to see you rehabilitated and successful than I do to see you in any form of unnecessary or overly burdensome punishment. So use this time on probation and these tools and resources that you are being given as what they are, which is a hand up to help you get a handle on your emotions, move past this situation, better your relationship with your family, and keep this off your criminal record so that you can go into your adult life finally free and unrestricted and with no domestic violence convictions upon your record. That is the final sentence of the court. You will have to pay fines and costs as well. I'll total them at this time. Fines and costs in this matter total $1,035. That is the final sentence of the court. If you disagree with the court's decision, you may appeal it to the circuit court within 21 days. If you need the assistance of an attorney to do so, you can request one within 14. I'm going to place you into a breakout room right now, Mr. Price, so you can make a payment and a payment arrangement with my cashier. Do you have any questions for me?
Thank you, Your Honor.
You're welcome, sir.
Thank you, Your Honor.